In this video, we are going to talk about Doctrine of Laches. A simple meaning of Laches is an unreasonable delay in pursuing a right or claim which can bar a party from obtaining equitable relief. So where there is a delay in pursuing a right or claim, then that delay should not be unreasonable, or that delay can be explained, the reasons can be given to the court that these were the reasons for this delay. So unreasonable delay should not be there, and there, if this unreasonable delay is there, Doctrine of Laches comes into play, and court can deny to entertain that right, that belated claim which the one individual is going for before the court. So the principle is based on this maxim: equity aids the vigilant, not those who slumber over their rights. The Latin maxim is vigilantibus nor dormentibus jura subvenient. So this means that the law assists those who are vigilant and not those who sleep over their rights. So to understand this simply, that an individual knowingly not coming to the court within a reasonable time period to claim any right which was in his knowledge accrued to him, but he is not coming within a reasonable time, and especially where the things are during that time has changed, the interest of the different people have changed there. So these are the reasons why this principle of equity comes into play, and the courts on the basis of this doctrine dismiss the claims of the parties. So there are some important elements of Laches. First is unreasonable lapse of time must be there. There must be a significant and unreasonable delay in asserting the right or claim. The delay should be substantial enough to raise questions about the timeliness of the action. So delay should be substantial enough, right? Now, neglect to assert a right or claim. So the party invoking Laches must show that the opposite party neglected to assert their right or claim within a reasonable time frame. This neglect is crucial enough in establishing the delay was not justified. So if a plaintiff petitioner files a writ petition before any High Court or Supreme Court, then it is the responsibility of respondent to establish that there is Laches and there is a delay, unreasonable delay, and that must be established before the court, that why this principle is attracted. So this is the burden of the respondent. And then the third one, detriment to another. So it says that delay must have caused prejudice to or detriment to the opposite party. This could manifest as a change in circumstances that would make it unfair to allow the claim to proceed after such a delay. So even after a delay, the court is allowing the claim and ready to entertain a claim. Even there is a delay, then it is also to consider whether prejudice or anything detrimental to the opposite party is not there. Court must consider that are there any change in circumstances which may affect, or it may be unfair to allow such a claim after a long delay in that claim. So this is the third element. Now we are going to discuss some examples of Laches there. So in case involving the recruitment of primary teachers, the court dismissed a writ petition filed 2 years after the result were declared, emphasizing the need for prompt action in recruitment process. So this was a case where the recruitment was challenged of primary teachers, and the petitioners filed this writ petition after 2 years after the result was declared. So this is obviously reason is that there may have been some appointments already made from the authorities, and people might have entered to offices there. So after such a delay where things have taken place, there may have been some change in circumstances. So in such cases, principle of the Laches is attracted. Now in case of Shankar Cooperative Housing Society Limited versus M. Prabhakar and others, and 2011. So in this case, the relevant considerations while deciding that there is Laches, delay in Laches in cases and in writ petitions under Article 226. So there were some considerations given by the Apex Court. Number one says there is no inviolable rule of law that whenever there is a delay, the court must necessarily refuse to entertain the petition. It is a rule of practice based on sound and proper exercise of discretion, and each case must dealt with on its own facts. So even if there is delay, the cases must be dealt within its own facts. It is not necessary that if there is delay, the doctrine of laches will be attracted in all cases. It is not necessary that if there is a delay, then in some cases the delay may be explainable. It's not always the rule that even in all the cases, if there is a delay, then laches, the doctrine of laches must be applied, and the writ must be dismissed, the petition must be dismissed. It is not the rule. It depends on the facts and circumstances of each and every case. So this was the principle. Now, number 2 says the principle on which the court refuses to relief on the ground of laches or delay is that the rights accrued to others by the delay in filing the petition should not be disturbed unless there is reasonable explanation for the delay, because court should not harm innocent parties if their rights had emerged by delay on the part of the petitioners. So it simply says that if there are some rights accrued to other people due to this delay in filing the petition, that should not be disturbed unless there is a reasonable explanation given, because it is the principle that the innocent parties should not suffer due to delay on part of the petitioners. So then third principle says the satisfactory way of explaining delay in making an application under 226 is for the petitioner to show that he had been seeking relief elsewhere in a manner provided by law. If he runs after a remedy not provided in the statute or statutory rules, it is not desirable for the High Court to condone the delay. It is a material what petitioner chooses to believe in regard to the remedy. So it says that he must have been, if somebody coming to the High Court with a long delay, and he says that he was seeking relief elsewhere, if there was any alternative relief available to him and he was seeking that relief, that must be provided in the statute, or there must be, that should have been the legal remedy he was opting. If he was doing something wrong with regard to, he was going to wrong forum, meanwhile this cannot be a ground for condoning the delay there. So this was the principle third. 4 says no hard and fast rule can be laid down in this regard. Each case shall have to be decided in its own facts. And then 5 says that representations would not be adequate explanations to take care of the delay. So these were the 5 principles postulated in this important judgment, and the court should take care of these principles while deciding the ground of laches, the delay in filing the petitions. Now another aspect there, when some people wait for relief in a similar or other petition to file their own petition. If they hear about that in another case this relief is given, and they file the petition afterwards. So this is the judgment for that in SS Balu and others versus State of Karnataka, it was held that the delay defeats equity and that relief can be denied on the ground of delay alone, even though relief is granted to other similarly situated person who approach the court in time. So this was held that already some people approached the court there, and when they succeeded, some other people are coming on the basis of that order. So here on the basis of this judgment, it was held that it defeats the claim because there is a delay, and even if there are cases where the similar relief was granted, the delay itself would be sufficient to dismiss the case. And now obviously there are certain exceptions and limitations of this doctrine. First says that the doctrine of laches is not absolute. It is a petitioner, if a petitioner can demonstrate a strong case on merits, if the merits of the case are so strong that the delay would be a secondary thing, so in those cases court, even if the delay is there, then it can allow to enter in the case on merits. Second says if petitioner has made representations regarding their claims that were not considered, the doctrine may not apply. For example, in a promotion case, the court found out that the doctrine of laches was inapplicable because the petitioner had made representations that were ignored. So if somebody's representations were not decided or were ignored by the department and they were waiting for those to be decided, in such circumstances the delay can be condoned on that ground. So these are the exceptions and limitations. Now some simple facts about the doctrine. It is a doctrine of equity, right? It is a doctrine of equity. Secondly, there is now this doctrine was already available even before the Limitation Act was there. So before this Limitation Act, there was this doctrine was available for cases to be decided which were filed after a long delay. So but now Limitation Act is there. So for cases for things which are already provided in the Limitation Act, the cases are the delay and the timeliness of the question of timeliness of the cases should be decided on the basis of the Limitation Act, which are provided for things, for applications or suits which are already provided in that act. Now, for writ petitions, Limitation Act is not applicable, but Doctrine of Laches is there. For delay in filing a civil suit, so Limitation Act plays a role. Limitation Act has provisions about the same. So, for example, if civil suit is to be filed within 3 years, then it must be filed within 3 years. So, this is the principle settled by the law, Limitation Act, that 3 years the time limit for filing a civil suit. Now, for writ petition, there is no certain time period. So, in cases where the delay is unreasonable, then laches is applicable. So, delay may depend on the facts and circumstances of the case. There in Limitation Act, section 3 bars the suit after after expiry of limitation period provided there in act itself. Also there is section 5 and section 5 of Limitation Act provides that if appeal and application, so it's not for suit, it's appeal and application. For appeal and application, if there is a delay, that delay can be condoned, and there must be some sufficient reason shown to the court for this delay to be condoned. So, this is to be remembered, that for those cases which are covered under Limitation Acts, applications, suits, appeals, whatever, those are to be decided on the basis of limitation period provided there in the Act. For things which are not covered by the Limitation Act, those are to be decided by the Laches, principle of Laches. Thank you so much for watching. If you are new to the channel, please subscribe it. Thank you.